I will be honest with you. This is a section of the chapter we are not going to spend a great deal of time on. If you are interested in the Bill of Rights, then I highly recommend that you sign up for APGov next year because we have an entire section where we're just talking about civil liberties and we go through all this stuff. So, this is just going to be something of an overview, just kind of hit the highlights. We are not going to go in depth or anything. We do go in depth in APGov, but for here and now, it's not going to be a big aspect of it. What I do want you guys to understand, however, is that the entire ratification of the Constitution really, you could argue, depended upon the adoption of a Bill of Rights. A lot of the states that had gone through and had voted for ratification of the Constitution had done so on the express condition, essentially, that there would be a Bill of Rights added. Okay, the Anti Federalists had had a great deal of concern about the fact that there was no Bill of Rights. The argument against the Bill of Rights was that the Constitution already protected these rights they were talking about, that the individual states also had done so, and there was the fear that by listing them, it would limit in the future, saying, well, it's not specifically listed here, therefore, that kind of thing. However, they did go through and did add it as sort of a bargain, and we have studied it at length in the 200 years since then. The actual procedure they went through is they actually proposed 12 amendments, 10 of which were passed right back then. One didn't get passed until about 1993. Long story on that one. And one of them was just tossed entirely. So, generally speaking, while they did only get, at the time, 10 out of 12, they had done what they had promised to do. Okay. Now, the necessary number of states adopted the Bill of Rights in 1791. Remember, the way that it works is at any amendment to the Constitution, we'll use the path that they did. There's actually two. Again, take APGov. There's basically you can get 2/3 of the House and Senate to propose the amendment. It then goes out to either 3/4 of the legislatures, or again, you can have ratifying conventions, things like that. So in this case, they had put forth the 12 different proposed amendments. 10 of them were ratified by the states starting in 1791. Okay, and so for the Bill of Rights, we're just going to kind of, like I said, do a brief overview. We're not going to go in depth for our purposes. Okay, first and foremost, you have the First Amendment, Amendment number 1. Now, this contains actually 5 protections: freedom of religion, speech, press, assembly, and petition. You have the right to practice whatever faith you wish or none whatsoever. You have the right to actually speak your opinion. You can print what you want to print, especially we're talking here about, especially newspapers in regards to criticism of the government. The right to assembly. You can gather in groups and you can petition the government, as it says, for a redress of grievances. So if you feel the government has done something against you, you can petition the government to fix that problem. Okay, so basically the way I learned it was speech, press, religion, association, and petition. Okay, Second Amendment refers to the right to keep and bear arms. There are 2 parts to the Second Amendment. It says a well-regulated militia being necessary for the survival of a free state. Then I believe it's a semicolon, and so then it's another thought. The right of the people to keep and bear arms shall not be infringed. The argument has long been that only qualifies toward militia in regards to government service. There is a great deal of argument over that. Again, we're not going to go into the debate on that now. As I've said like 8 times so far, take APGov. We argue a lot in there. Third Amendment, soldiers cannot be housed in civilian homes during peacetime. This had been a problem with the British Crown, you might recall, that they could dispatch troops and then it was the responsibility of the colonies to basically pay for their food and housing. Okay, so we wanted that placed into the Bill of Rights to make sure that that would not be a problem again. Fourth Amendment, no unreasonable searches. All searches require warrants, and those warrants must be based upon something called probable cause. Basically saying that the government cannot simply decide to search your home whenever for whatever reason. There has to be a reasonable cause that they want that, and then you have to have a judge sign off on the warrant. So a lot of these you're going to see basically deal with your personal rights in regards especially to and government investigations and stuff like that. Fifth Amendment, a lot of people have heard this one. You've seen it in movies and stuff like that, where they say, I refuse to speak on the grounds that I might incriminate myself. It is your right to not testify against yourself. In other words, you do not have to go through and help the government make their case against you. In our system, you're innocent until proven guilty by the government, and they cannot force you to help them do that. They also have a thing in here called double jeopardy, which means if you are put on trial for a murder or something like that, and you are found not guilty, even if they find great evidence the next day, they can't try you a second time. They only get one bite at the apple. That is different than if they go through and there's a mistrial where they can't make a decision, then they have the right to try again. But if the jury comes back not guilty, well, then there is nothing you can do about it. Sixth Amendment is the right to a speedy and public trial. It is the idea that they cannot hold you indefinitely, and what's more, the trial is to be open to the public and a matter of public record, as opposed to being tried in secret and then you just disappear into wherever. The Seventh Amendment, right to a trial by jury when the sum of damages and whatnot exceeds $20. $20 was a lot more back in 1791, but the important thing is you get the right to a trial by jury. A lot of people will work exceedingly hard to get out of jury duty, but at the same time, it is one of the ways that we're guaranteed protection against the abuses of a government. Okay. Eighth Amendment is a great one because it talks about no excessive bail or fines. Plus, you can also throw into that one that I didn't write it down here. You have the protection against cruel and unusual punishment. So in this one, if you are arrested, they cannot make your bail like $60 trillion or something like that. And what's more, there is the aspect of cruel and unusual punishment. Bear in mind what we consider cruel and unusual punishment and what the framers considered cruel and unusual punishment may not always match up. And it just depends on some things on your particular point of view. The Ninth Amendment, other rights not enumerated are also in effect. What this basically means is, quite literally, just because we didn't list it here doesn't mean it's not a right. I give you, for example, the right to privacy. There is no right to privacy found in the Constitution. However, the court has gone through over the course of time, and based on other rights and things within the Constitution, we do now have a right to privacy. Okay, it's not listed here, but it does exist. Okay, there is also the unlisted powers belong to the states. Okay, in other words, what happens with the 10th Amendment is if it's not specifically mentioned in the Constitution and it's not specifically prohibited by the Constitution, the Constitution doesn't give it to the federal government and it doesn't say it's illegal, then that right or that power remains with the states. So again, this is just, like I said, a very brief overview of the Bill of Rights. I highly recommend you take AP Gov next year. We actually, like I said, we have a whole section on this, and we actually argue about some of this stuff, so that's always a plus. Now, in addition, rights, you also get in 1789 the Judiciary Act. Now, this is very, very important because essentially what the Constitution says about the judiciary, about the judicial branch, it says that there will be a Supreme Court and other inferior courts that Congress may establish, basically. So this was the first time Congress went through and it created the federal court system. Now, the individual states have their own courts, of course, but now we have a federal system as well, and there are multiple levels to that. You have the district courts, and then you would eventually have the appellate courts where you could appeal the decision from the district court, and then you have the Supreme Court where you could appeal the appeal. And so the Judiciary Act started to set up the federal court system. It's also Congress's decision as to how many justices actually sit on the Supreme Court. At present, it is 9, but it has been, at least at one point, believe it or not, it was 10. And you can imagine the problem with having an even number of justices is you can have a tie. So not long after the Civil War, one of the justices, I believe, passed away, at which point they decided, all right, let's just leave it at 9. And it has been that ever since. But it was the Judiciary Act of 1789 that actually began the creation of the judicial system that we have in our nation today. And it was at this time that John Jay, who had been one of the authors of the Federalist Papers, is nominated and is approved through the Senate to become the first Chief Justice of the United States. One way that you can look either clever or smart alecky, I leave it up to you, is if you've ever seen on the news, if you're watching the news with your family or whatnot, and you hear the newscaster make the comment about the Chief Justice of the Supreme Court. There is no such job as Chief Justice of the Supreme Court. When you hear them say that on the news, feel free to kind of chuckle to yourself and then turn to the people you're watching the news with and go, actually, the job title is Chief Justice of the United States. And that will either make you look brilliant or annoying. Now, I totally leave that option up to you.